Welcome to the ALTA Native American Land webinar series. This webinar is part one of a four-part series of webinars to be presented by the ALTA Native American Lands Committee. I am Cindy Guanell, the Native American Lands Committee Education Co-Chair, and I would like to introduce today's speakers. Sean Holland is an underwriting counsel in Fidelity National Title Group's Seattle Underwriting Department. He is the 2019-2020 president of the Washington Land Title Association and is a Washington title professional. Sean is a member of the ALTA Native American Lands Committee, State Legislative Regulatory Action Committee, and Title Council committees. Paul Cozzi joined the Fidelity National Title Group in 1998, where he is currently a member of the senior underwriting staff. Paul is past president of the Illinois Land Title Association, has served on its board of directors, and is active with several ILTA committees. He is also a member of the ALTA Native American Lands Committee. Branden Allen has been underwriting counsel for Old Republic in the Rocky Mountain region since 2013. Prior to that, he worked as general counsel for a title agency and also spent time in private practice. Branden is also a member of the ALTA Native American Lands Committee. Today's program will cover ownership of land, how title is vested, and what it means. We will also explore the Indian Non-Intercourse Act at 25 United States Code, Section 177, and Section 17 corporations. With that, I will now turn this over to Sean to talk about vestings. Sean?
The ownership of land in the United States is generally based on ownership of a fee simple estate. But when we discuss Native American lands, it is necessary to be aware of the types of interests unique to this area. The different types of vesting derive from the history of the relationship between Native Americans and the federal government. This slide shows two terms, Indian country and reservation, and the variations of vesting that I will cover in this presentation. The term Indian country is used frequently in federal statutes and regulations. The term includes all land within the boundaries of a reservation, regardless of how title is vested and who the owner is. Indian country is also land that is held in trust by the United States for a tribe or an individual Native American, both within and outside the boundaries of a reservation. It also includes land that is held by an individual Native American in restricted status, which can also be inside or outside of a reservation. The land comprising a Native American reservation that benefits a tribe was originally designated by treaty, statute, or executive order. Reservations were typically areas that remained or were reserved after tribes ceded the vast bulk of their traditional lands to the federal government. Reservation boundaries can be expanded through litigation, settlement with the federal government, or through reservation proclamations granted to a tribe by the Secretary of the Interior in connection with a completed trust acquisition. Reservations may be diminished only by an act of Congress. A person dealing with Native American land titles for the first time might assume that all land lying within a reservation has the same status. This slide shows the Crow Reservation in southeastern Montana. But instead, due to historical developments, in particular the transfer of title into non-native persons during the allotment era, vesting of title on the Crow Reservation, as on many other reservations, is marked by a wide variation in the types of interests. This slide shows the various ways title may be held both on and off reservation. The only difference between the two lists is the inclusion of vesting in restricted fee status on reservation. There is an opportunity to hold title in trust or unrestricted fee ownership both on and off reservation. Notice also that there is a distinction between tribal property and the property of individual Native Americans. Let's talk further about what these terms mean. Tribal property is land held in common for the benefit of all tribal members. Individual tribal members generally have no enforceable individual rights to any portion of tribal property. Tribal property is not public property of the United States. The three types of tribal property are restricted fee lands, lands held in trust by the United States for a tribe, or lands to which a tribe has unrestricted fee ownership. Restricted fee lands are the only type that must be located on a reservation. Individual Native Americans have a property interest only in land for which they are identified as a party holding an interest. While treaties and cases refer to tribal property as land held in common, individual Native Americans are not tenants in common in tribal property. The three types of interest that individual Native Americans may hold are restricted fee, land held in trust by the United States for an individual, and unrestricted fee ownership. Restricted fee lands are the only type that must be located on a reservation. Tribal trust land is land to which legal title is held by the United States in trust for the tribe. For example, the vesting deed will actually show the United States of America in trust for a tribe. The tribe in this scenario is considered to have a beneficial ownership in the property. This is similar to the trust relationship created through allotments. Tribal trust land may be land within a reservation that was never allotted and remains in tribal hands, or land acquired by the United States in trust for the tribe. At any time, a tribe can file an application with the Department of the Interior to have land they own in fee transferred to the U.S. to be held in trust for the tribe. There are regulations governing this process, which is referred to as a fee-to-trust transfer. The Bureau of Indian Affairs has a handbook on their website outlining the steps for this process. The application can be for land the tribe owns in fee, either on or off the reservation. The fee-to-trust transfer can be discretionary, which means the Secretary of the Interior has ultimate decision-making authority to accept or deny the application for acquisition. It can also be mandatory, which means that the acquisition is directed by Congress or judicial order that requires the Secretary to accept title to land into trust. The application for a fee-to-trust transfer can also be coupled with a request for a reservation proclamation. If approved, the reservation proclamation can add property to an existing reservation. This is more common when a tribe has acquired land in fee immediately adjacent to their reservation and they want to put it into trust to make it part of their reservation. Due to a change in the regulations in 2016, a title insurance policy is no longer required for fee-to-trust transfers. Instead, a commitment may be provided or title evidence meeting U.S. Department of Justice standards. Whether a policy is purchased is up to the local BIA agency office that is processing the application. However, when the acquisition is insured, it is typical to issue an ALTA U.S. policy form since the named insured is the United States of America in trust for the tribe. The transfer is completed by entering a record with the BIA Land Title Records Office. The Puyallup Tribe of Washington State has a reservation located near Tacoma in Pierce County. In 2004, the tribe acquired land within its reservation boundaries to establish a casino. The last conveyance appearing in the records of Pierce County is the 2004 deed conveying the fee title to the tribe. The subsequent fee-to-trust transfer was entered into the records only of the BIA Land Title Records Office. Sometimes the transfer will be recorded with the county, but you cannot rely upon county records accurately reflecting the status of title. A check of the records of the Pierce County tax assessor will indicate that the taxpayer of record is the, quote, USA Trust, end quotes. However, land held by the United States in trust for a tribe is exempt from local or state taxation. The BIA Land Title Records Office is where all documents affecting title to lands held in trust or restricted status are entered. The LTRO records are not open to searches by the public. The only way to obtain the information is to request a title status report. Some LTROs will accept a request for a TSR from a title company. Others require the property owner to make the request. If a tribe or an individual Native American owns land in fee with no restrictions, there is no requirement for documents affecting the title to that property to be recorded in the LTRO. Additionally, once a parcel of land is no longer subject to restrictions on alienation or the trust status is terminated, the LTRO stops maintaining records for that property. They will not issue a TSR for any fee land, so obtaining historical records from when the property was held in trust or restricted status is not an option. Tribal fee land includes land held in fee ownership by the tribe with no trust relationship present or no express restrictions on alienation. It is not clear whether alienation is restricted by the Non-Intercourse Act. Later on, the Non-Intercourse Act will be covered in detail. The Dawes Act in 1887 authorized division of reservation land into parcels of land called allotments. The beneficial interest in the allotment was conveyed by the United States to an individual Native American called the allottee, similar to a grantee. However, the United States maintains legal ownership of the land, acting like a trustee for the allottee. This is commonly referred to as holding title in restricted status because the allottee is restricted from conveying or encumbering the property without the federal government's approval. The allotment patent provided for the land being held in trust for 25 years. That period was often shortened. If the United States subsequently issued a fee patent, the restrictions were lifted, the land became subject to local taxes, and future conveyances were recorded with county offices, not the LTRO. The allottee could not sell or devise allotted land. Heirs acquired fractional shares. The fractionalization became extreme with some properties. A parcel on the Lac Courte Oreille Reservation in Wisconsin recently had over 1,200 owners. Once fee patents were issued, title was often conveyed to non-natives. The use of allotments led to more than 90 million acres passing out of native ownership. Much of the allotted land had been previously reserved by tribes in treaties. The issuance of fee patents for allotted land was thought by some to have diminished the boundaries of reservations. The state of Oklahoma made that argument with respect to the Creek Reservation, but in July 2020, the United States Supreme Court held that the conveyance of unrestricted fee did not affect the reservation status of the land. The case involved the issue of whether state or federal law applied to criminal offenses. It did not resolve the question of tribal authority over land in non-native ownership within a reservation. The allotment policy was ended by the Indian Reorganization Act of 1934. The IRA also extended the 25-year trust term indefinitely. The result was to hold allotments in trust status. As of 2012, approximately 11 million acres were still held as allotments. An individual allottee may apply to remove the restrictions, but the Secretary of the Interior is not required to approve the request and may decline if removing the restrictions would adversely affect the tribe or individual Native Americans. This slide contains an allotment patent issued in 1907 to a Native American for land on the Crow Reservation in Montana. This is a detail from the same patent, showing the language providing that the United States will hold the land thus allotted, subject to all statutory provisions and restrictions for the period of 25 years in trust for the sole use and benefit of the said Indian. The patent further provides that at the end of 25 years, the U.S. will issue a fee patent and the land will be discharged of said trust and free of all charge or encumbrance. In 1931, the United States issued a fee patent to the original allottee for a portion of the land. The language used makes it clear that the U.S. is no longer holding the land in trust. Individual Indian fee land includes land that is owned in fee by one or more individual Native Americans. This can be land that was originally allotted for which the trust status was later terminated, as in the examples of the 1907 and 1931 patents that were just discussed. It can also be land acquired in fee by a tribal member as opposed to being held in trust. No federal restrictions apply to conveyances or encumbrances, and local taxes may apply. Conveyances are recorded with county authorities. The LTRO does not maintain records for individual fee land. Individuals who are not Native Americans may hold unrestricted fee to land within reservations. This is land for which the trust or restricted fee status has been terminated, often as a result of the allotment policy, and title subsequently passed into non-native ownership. Conveyances of unrestricted fee property are recorded with the county, not the LTRO. That's the end of my section of the presentation. The next portion will be done by Paul Cozzi on the Indian Non-Intercourse Act.
Thank you, Sean. The applicability of the Indian Non-Intercourse Act, a federal statute as Sean referred to real estate transactions involving Native Americans is one of the most difficult and complex subjects we deal with. This is mainly because of the divergent opinions on its applicability to transactions involving fee ownership of lands by tribes and tribal entities. The tribes, their council, the BIA, lenders, and other parties believe it does not apply, and many of us insuring these transactions for good reasons feel otherwise. The Indian Non-Intercourse Act is found, as I mentioned previously, at 25 U.S.C. Section 177, which addresses purchases or grants from Indian tribes and provides in pertinent part: no purchase, grant, lease, or other conveyance of lands or of any title or claim thereto from any Indian nation or tribe of nations shall be of any validity in law or equity unless the same be made by treaty or convention entered into pursuant to the Constitution. There's also regulations thereunder, or a regulation thereunder, at 25 Section 152.22, and in pertinent part is to tribal lands. In paragraph B thereof, tribal lands held in trust by the United States for an Indian tribe, lands owned by a tribe with federal restrictions against alienation, and any other land owned by an Indian tribe may only be conveyed where specific statutory authority exists, and then only with the approval of the Secretary, unless the act of Congress authorizing the sale provides that approval is unnecessary. The Indian Non-Intercourse Act was first enacted in 1790 by the very first U.S. Congress. It was amended and extended several times in 1793, 1796, 1799, 1802, and 1834. It has been in its present form since 1875. The underlying legal basis of the Act are the concepts of aboriginal title and the doctrine of preemption. Aboriginal title consists of a tribe's right to possession of its land, subject to the preemptive right of the sovereign to acquire the land if and when the tribe decided to sell. The doctrine of preemption basically is the discovering nation, by virtue of its discovery, obtained dominion and sovereignty over the land discovered. The Indian tribes, as native occupiers, continue to hold the right of possession, but subject to the sovereignty of the discovering nation. And the discovering nation, the sovereign, had the exclusive right to acquire the interest of the tribe in the land if and when the tribe decided to part with it. Here is a slide showing a law of Virginia from October 1705, the then county of Virginia, that bears some very similar terminology and tone to that of the Indian Non-Intercourse Act. As it reads, it was enacted by the governor, the Council of Burgesses of the present General Assembly, and it states that it shall not be lawful for an Indian king or any other of said tributary Indians whatsoever to bargain, sell, or demise to any person or persons other than to some of their own nation of their posterity and fee for life or for years the lands laid out and appropriated for the use of said Indians or any part or parcel thereof, or to bargain and sell as aforesaid any other land whatsoever now actually possessed or justly claimed and pretended to by the said Indians or any of them, and that every bargain, sale, or demise hereafter made contrary to this act as aforesaid shall be and is hereby declared null and void to all intents, constructions, and purposes whatsoever. There has been some time before even the founding of this country, a special relationship between tribes and the government. Special relationship between the Indian tribes and the federal government predates the formation of the United States. The Proclamation of 1763 declared certain lands to be under domination and control of the Crown for the use of the Indians. Sovereignty over the land and the right of preemption as to Indian lands moved from the English Crown to the United States government following independence and the Revolution. Thereafter, has been a line of several cases dealing with this special relationship. One was Johnson versus McIntosh from 1823, holding the federal government has the ultimate title and tribes have title of occupancy. Ultimate title is not ownership, it is a right of preemption. Title of occupancy includes full and exclusive possession. In Cherokee versus Georgia in 1831, we found the first use of the term domestic, that tribes are domestic dependent nations who in exchange for ceding their land obtain promises from the U.S. of protection. Statutorily, as referenced earlier by Sean, the General Allotment Act of 1887, the Dawes Act, was the first statute to use trust to describe U.S. holding of land, in this case, for allottees. Then the Indian Reorganization Act of 1934 authorized the Secretary of Interior to take land in trust for tribes and individuals. The Non-Intercourse Act, these cases, the Dawes Act and the Indian Reorganization Act, are counter to the common presumption that land titles are freely alienable. Now, as I mentioned before, the first Congress enacted the first version of the Indian Non-Intercourse Act the year after the adoption of the Constitution. This confirmed the federal government's position as the successor to the Crown as holder of the right of preemption and its control over the acquisition of lands from tribes. This has led to our present day confusion as to the applicability of the Indian Non-Intercourse Act with respect to tribally owned fee simple lands. This divergence between the Act is based on judicial and congressional and administrative authorities. 19th century Attorney General opinions, the legislative history, occasional congressional findings, and the Department of the Interior regulations lead to the conclusion that the Act applies to tribal fee lands just as it does to any other tribal lands. A number of tribes desiring to sell or encumber their tribal fee lands have sought and obtained from Congress authorization to do so through specific legislation applicable to their tribes. The legislative history of those acts generally makes little reference to the court decisions, but simply refers to the plain wording of the Act. Some federal and state cases hold that once land has been patented and placed in the public domain, the acquisition of that land by a tribe does not render it subject to the Act. However, none of these cases refer to the congressional findings or the legislative history of the various acts authorizing specific sales and encumbrances of tribal fee lands, nor to Attorney General opinions or the Interior Department regulations. Other cases support a broader application of the Act, but did not lead to any invalidation of any transfer, and those cases did not discuss the congressional or administrative authorities. The bottom line is there's no clear exception in the Act or the regulation thereunder as to tribally held fee simple lands. This confusion creates issues insuring such conveyances of title, and it impacts at least two covered risks. One is covered risk to the failure of any person or entity to have authorized the transfer of conveyance. And this really relates to the fact that we have a statute that would seem to, that clearly in some views applies to all lands owned by tribes and would require some further authorization to have a tribe convey the land other than the tribe itself making that determination. It also impacts the coverage for unmarketable title as the initial conveyance out of the tribe may be subject to question down the road or even possible litigation as to whether it was properly authorized. So what do we do? Well, the ALTA Native American Land Committee has been encouraging for some time that this act should be clarified in terms of its scope, and that can seemingly be easily done by simple wording that makes it very clear that the act would apply to restricted lands and lands held in trust. And although it has been difficult to focus Congress's attention on this act in the immediate and current political climate, we will continue these committee efforts and hopefully get that resolved at some point. For the present time, each title insurance underwriter will have to decide how to deal with the applicability of the Act when insuring a conveyance by a tribe or tribal entity, i.e., whether or not to raise an exception for the Act or what form of clearance, if any, to require. Also, whether to consider the applicability of the Act to post-policy conveyances when insuring an acquisition of land in fee simple by a tribe or tribal entity in light of the covered risk for unmarketable title. And now I will turn the presentation over to Branden, who will talk about Section 17 corporations.
Tribes have become increasingly sophisticated with how they transact business, involving more non-tribal member partners, investors, and lenders. Particularly in the energy industry, tribes are transitioning from being passive owners of resources to innovators for how they own, develop, and produce additional resources. Like any other business, tribes must compete to attract more economic activity. Investor risk is often raised by uncertainty with regulatory policies and concerns about enforceability of contracts and agreements with tribes and tribally owned business entities. Often that concern centers around tribal sovereign immunity from suit and federal approvals. My portion of the presentation focuses on some of the methods, including Section 17 corporations, which allow tribes to transact business. From the historical perspective, Section 17 corporations came about as part of the passing of the 1934 Indian Reorganization Act, which is also known as the IRA, Wheeler-Howard Act, or the Indian New Deal, as it was sanctioned by President Franklin Delano Roosevelt. Congress had many goals with the creation of the IRA, but the two that I'm going to focus on are the ability of the tribes to be able to adopt their own constitutions and to give them the opportunity to incorporate themselves. Section 17 of the IRA was specifically intended by Congress to restore economic prosperity to the tribes through encouragement for them to transact business with non-tribal members and corporations. Tribes were not automatically subject to the IRA, as they were required to consent to it. 77 tribes wholly rejected the IRA to its full extent, and some tribes accepted and rejected portions of it. Even with the tribes that had rejected acceptance of parts or even the entire IRA, in 2004, Congress amended the IRA to clarify that each tribe retained the ability to adopt governing documents, even if they were not members of the IRA. So what is a Section 17 corporation? Section 17 of the IRA itself is just one paragraph of text. It provides the following. The Secretary of the Interior may, upon petition by any tribe, issue a charter of incorporation to such tribe, provided that such charter shall not become operative until ratified by the governing body of such tribe. Such charter may convey to the incorporated tribe the power to purchase, take by gift or bequest, or otherwise own, hold, manage, operate, and dispose of property of every description, real and personal, including the power to purchase restricted Indian lands and to issue and exchange therefor interests in corporate property, and such further powers as may be incidental to the conduct of corporate business, not inconsistent with law, but no authority shall be granted to sell, mortgage, or lease for a period exceeding 25 years any trusts or restricted lands included in the limits of the reservation. Any charter so issued shall not be revoked or surrendered except by act of Congress. That's found in 25 U.S.C. 477. So when Congress enacted Section 17, they knew that sovereign immunity concerns would arise with these types of corporations, and that these types of entities would need to be able to waive their immunity to further entice more parties to do business with them, which the entity is actually able to do by signing a waiver. Signing the waiver generally only waives immunity for the corporation itself, without waiving immunity for the actual tribe also. Section 17 corporate charters often contain a clause which is a sue and be sued clause. Please understand that this clause permits the tribe to file suit and to be sued, but in its corporate form, as opposed to being a government. But courts have held that the sue and be sued clauses do not waive the tribes acting either as a corporation or as a government immunity from suit. Therefore, waivers of immunity by Section 17 corporations are commonplace and are not necessarily the same thing as a waiver of sovereign immunity. With the statute and its regulations containing little guidance on these types of entities, there is now some flexibility procedurally with the requirements of Section 17 corporation charters, which will have to be met. Nonetheless, a Section 17 corporation must be wholly owned by the tribe and cannot have any equity ownership by outside investors. It is separate and distinct from its tribal government, generally has its own directors, and does not involve its tribal council in the day-to-day management of the entity. If the corporation defaults on the payment of funds it is borrowed, the liability will extend only to its own assets. With that being the case, for the corporation to be able to engage in business and to have collateral to be able to leverage, it makes sense that its land and assets that the corporation will use have to be conveyed or set aside for that entity to be able to do that. In the early years of Section 17, the BIA was very restrictive and used standard forms for the creation of the corporation. However, although the BIA suggests a template that the tribes may use, tribes may choose to write their own charters that include their own provisions and are specific to that tribe. So if you're dealing with a Section 17 corporation, you should definitely do your due diligence by reviewing relevant tribal law and its charter provisions and any bylaws of the corporation to make sure that you know who can act on behalf of and to bind the corporation, which it usually will be a board of directors, but it doesn't have to be. You also want to make sure that you know what action requires approval, to what extent the assets of the corporation can be used as collateral to secure obligations, and what steps the corporation must take to waive its sovereign immunity from suit. Remember that any amendments to the Section 17 Charter must be approved by the BIA. Now I'm going to talk about the setup of how to set up a Section 17 corporation. But before I go into the steps for how to create one of those, a big thing I want you to keep in mind is that these types of corporations are creatures of federal statute. They have very rigid formation guidelines. They can only act within the powers specified in the corporation's charter. Shares cannot be sold or devised, even to tribal members, except under very limited and certain circumstances. And once created, they are tough to amend and to dissolve. So if any of the steps that I'm about to talk about for the formation of a corporation, a Section 17 corporation, fail, then you don't have a Section 17 charter, and you're really left working directly with the tribe, and additional BIA approvals may be required. So here are the actual steps to setting up this type of charter. 1, the tribe drafts the corporate charter. This is similar in form and scope to the Articles of Incorporation, but usually has more detail. The charter contains the organizational framework for the entity and must be structured as wholly owned by the tribe, but separate and distinct from tribal government. The tribe may use the BIA's suggested template or even tailor the charter to fit their own tribal needs. 2, the tribe approves the charter. This approval process is set forth by the tribal law and not by federal code. Typically, approval will be by resolution by the tribe's governing body, which is generally called the tribal council. 3, the tribe takes the resolution and charter to the BIA. The BIA will review the submission to ensure that the resolution is duly adopted in accordance with tribal law and that the charter contains no provisions that are contrary to federal law. And step 4, the BIA approves or rejects the charter. This is usually a fairly slow process, doesn't have to be, but usually it is. And the last step is step 5. If the BIA approves, they send the charter back to the tribe with the approval, and the tribe must then ratify that approval. This approval is done by the passage of another resolution to ratify the charter and may require a vote of tribal membership. So once the charter is ratified, it is officially established, and at that point, it requires an act of Congress to be able to be revoked or surrendered, which has resulted in many Section 17 corporations being established over the years, but are now inactive because the tribes have not gone through the rigorous process to formally abandoning their corporations. So here are some advantages to Section 17 corporations. Taxation is a big one. Section 17 corporations are exempt from federal tax. Another is they have extraordinary powers. In addition to powers listed in the charter, a Section 17 corporation is allowed by federal law to buy land and to enter into leases or mortgages of tribal lands for a period of 25 years. Please remember, if a tribe were to do the same thing in this context, they would have to seek federal approval. The corporation is also allowed to enter into contracts and agreements that encumber tribal lands for a period of 7 years or more without BIA approval. And again, that's same thing. If the tribe were to do that, they would have to get federal approval. A Section 17 corporation can also issue tax-exempt bonds if the proceeds are used to finance essential government services. They also have other powers. The charters may confer such further powers as may be incidental to the conduct of corporate business, provided that they don't violate tribal or federal law. They also, having a Section 17 corporation, can limit risk to tribal assets. The corporation may obtain financing without the exposure of tribal government's assets to the risk and liabilities of borrowing money. Financial disclosures would also avoid disclosing tribal government assets and be limited to the actual assets owned by the corporation. And the last advantage that there's probably other advantages out there, but the last one that I think is important is familiarity. Non-tribal business partners, investors, and lenders may be more comfortable with doing business with this type of corporation as opposed to other entities formed by the tribe, since they are familiar. So there are alternatives if a tribe doesn't want to do a Section 17 corporation. As tribal sovereignty and the right of self-governance allows the right to control or participate in business activities, tribal business does not have to be just conducted with these types of charters, with the Section 17 charter. And many tribes have entities that function outside of the IRA. Tribes are able to form businesses under tribally enacted laws, federal law, under estates and corporation laws, though that's fairly rare, and by either formally incorporating or even being an unincorporated business that is not a distinct entity from the underlying tribe. So when making considerations to what type of business enterprises the tribe will select, some of the factors that they may consider are, the big one is sovereign immunity, whether it be applicable to the business entity as an instrumentality or an arm of the tribe, financial opportunities. They may look at tax implications, ease and timing of the formation, and existing tribal law. So tribal entities created outside of Section 17 face some likely challenges, the biggest being a lack of familiarity. With entities being organized in different ways from one another, obtaining a reliable legal opinion may be difficult. An entity could be set up by relying on its governing instruments from tribal history, ordinances, resolutions, or other actions. It is imperative that you determine how the entity is formed and how it functions, as it could be risky to rely on advice from the tribe because it may not understand completely the implications of doing business in a certain way, and also who has authority to act for the entity. You should also review corporate documentation, including its organizational documents, to make sure that you have a comfort level to proceed in transacting business with the entity and have addressed the sovereign immunity aspect. While tribes rarely form wholly owned entities under state law, they sometimes own equity in business entities formed under state law. An example is a membership interest in a limited liability formed under state law. If you have a situation like this, it is extremely important to determine the structure of the corporation and the laws that govern that corporation, as well as the impact of tribal and federal law on the tribe's actions as equity owner. Some of the questions possibly to ask are, is the tribe's council affirmatively, do they have an authorization, the required authorization for the entity to be able to take action, and do I need to get federal approval? Now I'm going to touch on just a couple of the types of entities that there are out there that are not under Section 17 corporations. The first is tribally chartered corporations. A tribally chartered corporation is an entity that is set up pursuant to tribal code with a resolution signed by the governing body of the tribe. No approval is needed from the federal government to organize one. Tribally chartered corporations exist in many forms today, including but not limited to tribally chartered colleges, nonprofit corporations, and as holding companies for other entities. These type of corporations would be unlike unincorporated tribal entities or political subdivisions because a tribally chartered corporation would have limited liability, and a creditor would only likely have access to the assets held by the corporation. Usually these types of entities are run by a board of directors that are elected by the shareholders, which is often just one shareholder, the tribe. The board would then likely elect an executive to oversee the corporation day-by-day operations, and the entity may be wholly owned or just partially owned by the tribe. Generally, with a tribally owned or tribally chartered corporation, the tribe will adopt a business corporation code, though they are not necessarily required to do so, that sets out the requirements of formation and regulation for this type of entity as to formalize its existence. This code should not conflict with the tribe's constitution and other laws. So when making a determination whether a tribally chartered corporation will have the same sovereign immunity as the tribe from suit, it's difficult to know whether sovereign immunity will apply or not. And it is in your best interest, if you are going to work with this type of entity, to seek a waiver of that immunity. Courts will usually look to very specific analysis to determine whether immunity will apply or not. Some of the things that the court actually looks at when they're looking to this is whether the tribal corporation has the power to bind the tribe's assets or obligate tribal funds, whether the tribe and tribal corporation are intertwined in governing structure. Another is whether the corporation is organized by for governmental purposes, and whether the entity is legally separate and distinct from the tribe. Another consideration with tribally chartered corporations is whether they are exempt from federal taxation or not. The IRS has not been extremely specific on what they were looking for, but generally when they do their analysis, they will look to see if the operation of the company is an integral part to the tribe when they're deciding whether or not tax will apply or not. The factors they usually look at are extent of tribal control, funds and profits sharing in the corporation, financial reporting, corporate governance, and whether the auditing is done independently or not of the corporation. Another entity I want to talk about real quick is a tribally chartered limited liability corporation. A tribally chartered limited liability company or corporation functions very similarly to a tribally chartered corporation. They are formed in accordance with tribal code and the action of the tribe's governing body. They offer another structure for tribes to be able to take advantage of. Most tribes will rely on just tribal law when they set one of these up to establish these types of entities and will not likely have separate tribal LLC code. The articles of incorporation or the operating agreement are formally filed with the tribe and likely will provide limited information, and it's often tough to determine what is permissible for these types of LLCs and what is not permissible. As is typical with most LLCs, the operating agreement, if they have an operating agreement, is going to contain more information related to the operational component of the LLC and what is permissible. As is becoming common all across the country, LLCs are becoming more and more desirable for investors with tribal entities because of their flexibility. They allow for these non-tribal members to own and participate in the management of the entity's business and to still limit their personal liability to just their stake in the LLC. It is also important to point out that you may have a situation where the LLC that you're working with has just one of multiple members. That is the tribe. If you're faced with this situation, you should question whether sovereign immunity is in play or not, and if it is, it's smart to obtain the waiver. It's also important to point out that if you have a situation that you're working with where you have an LLC has just one of its multiple members that is a tribe, that you know exactly what you're dealing with and how to handle the situation to make sure you don't run into problems. I'm just going to touch briefly on state chartered tribal corporations now. A state chartered tribal corporation is a tribal corporation that is wholly owned or partially owned by the tribe, and it's organized under state law as opposed to federal or tribal code. They're not used very often anymore because most tribes don't want to subject themselves to state liability as well as, or state jurisdiction. And the jurisdictional aspect has problems anyways, as have been addressed in other presentations that have been done today. Sovereign immunity also becomes interesting with tribes that are state chartered and should be evaluated on a case-by-case basis whether immunity applies or not. So in conclusion, tribes conduct business in a variety of ways as each tribe has its own values and culture and its own goals when it comes to what type of businesses they are trying to attract and with whom they are trying to do business with. Those Section 17 corporations may not be the best avenue for every tribe that is out there, and some think that the statutory scheme needs amended to be less rigid and allow for non-tribal investors to gain a membership stake in raising capital for the entity. It does provide an option for tribes to be able to attract business. So if a Section 17 corporation is not the best option for the tribe, there are other avenues that are not so rigid, yet have their own pitfalls to navigate. So when working with any tribe of the types of these tribal businesses, it is always important to figure out what you're dealing with and to be able to handle them accordingly. That's all I have. Thank you very much. I'll send it back to Cindy.
Thank you, Branden. If anyone has any questions about today's topics, please direct those questions to communications@alta.org. Again, that's communications@alta.org. But I think we have a little bit of time left that we can ask a couple questions today. So I'm going to start with Sean. Sean, you mentioned that the Supreme Court's decision in McGirt v. Oklahoma, you mentioned that decision, and that decision recognized the historic boundaries of the Muskogee Creek Tribes Reservation in Oklahoma. How does that affect the title of individual property owners and the title industry?
That's a great question, Cindy. The McGirt case confirmed that the historic boundaries of the reservation had not been diminished, contrary to decades of local practice and expectations. The case does nothing to change title to individual properties. The decision that the reservation retained its original boundaries meant that federal, not state criminal law applied. The effect on individual property owners in the title industry is that land that was once thought to lie outside a reservation is now confirmed to lie within, and all that follows: tribal authority to tax, tribal authority to regulate land use, and access concerns. These issues will need to be resolved in the courts or by the Congress. And I would note that we're recording this only 1 month after the decision was released, so we'll just have to wait and see how things shake out.
Very good point. Thank you, Sean. Paul, I'm going to direct this next question to you. How can we determine if a tribe has been exempted by Congress from the Non-Intercourse Act?
Thank you, Cindy. That's a good question. Well, unfortunately, it's not easy to find them, but basically what happens is a tribe will go to Congress, contact their local representative, whatever, to draft a bill that would basically state that they are free to transfer their fee-owned properties. And the laws are pretty similar in what they say. They specify that it's only these tribal fee properties, fee simple owned properties, and they usually have another the paragraph that says this doesn't apply to trust or restricted lands. However, if you were to look at, as I have, under, say, a search on Westlaw, under Chapter 25 of the Indian Lands, the chapter of the U.S. Code that has the Indian Land statutes, it's not easy. You usually don't find them there. It must be somehow the way the code is organized, because these are very specific types of legislation. So what I have personally done is that I usually come across them somehow. And basically, I think if you need to determine that, the best way to go would be to inquire, or if the tribe argues that they don't apply, that they provide you with a copy of the statute. And these are usually, for citation purposes, identified as PL 110-something or some reference to stat, which are not the typical types of citations we usually encounter when we're searching general laws. So I guess the short answer is two things, really. Is I have personally a list of several that I've come across that I keep. So you can ask your underwriting advisor what they know about the tribe, or more directly, the tribes often have recently one was provided by a tribe we were working with that I wasn't aware of until last week. So that's probably the best way to go, is to see what the tribe has on that. Because if they were involved, which they usually are, in the legislation, they usually work with somebody, their congressman or lobbyist or something, and they usually have some access to the document. And then you can using the citation in the document, verify that, search it out on your legal search process. And I know in Westlaw you can find them. If you know the citation, you can put a query in, and usually you can come across it in a PDF type form rather than on the code. U.S. code form that you usually see on these legal research tools.
Great, thank you, Paul. The last question I will direct to Branden. Branden, has the BIA become more strict or has it loosened up over the years in regard to Section 17 corporations?
Thank you, Cindy. So my thought on the BIA, looking back at the research that I found and over the years, it appears that the BIA has definitely loosened up their standards with Section 17 corporations as far as drafting of the corporate charter goes. As I discussed in my presentation, they have a form that they used to require on many of these corporations when they were being drafted, that they use the corporate form charter documentation provided by the BIA, but over time they've actually let up on that a bit and have allowed more tribes to be able to actually draft their own charters, which I think has been helpful because it seems like that's kind of the direction the tribes want to go anyways, is to be able to draft their own so that's specific to their needs and what they want as a tribe. So that's what I have on that.
Excellent, thank you, Branden. Okay, I'd like to remind everyone to please mark your calendars for the remaining webinar series. Part 2 is scheduled to be presented live on September 16th, 2020 at 1 p.m. Eastern Time. Part 2 will explore the statutory and regulatory authority and processes for leasing restricted Native American lands. Part 3 will be available in the second quarter of 2021 and will be a discussion about authority, recording in the Land Title Records Office, and access issues. Part 4 is the final webinar in the series. It's going to be a live case study applying what we have learned in the previous webinars, so you won't want to miss it. This will be presented in the third quarter of 2021. Thank you for viewing our webinar today, and have a great day.